Okay, we'll make this official now. Good afternoon. I'm David Biet. I'm director of the Canada Institute. Welcome to this sort of impromptu summer session. We don't usually do programs in the summer, but with two scholars this summer who eagerly wanted to talk about their research, we were happy to oblige and invite whoever wanted to come. Jim McHugh's been with us for almost a month or over a month now. Yep. Jim's chair of the political science department at the University of Akron. He had been in Washington a couple years ago at AU working on similar issues with Bob Pastor in North America. And I've known him for years, sort of in and out of the Canadian studies community. It was a real treat to have him with us this summer and also have his office be right next to ours, so we get to talk about stuff. Something else today, AV decided that they were going to webcast this. So this is live webcast. Hello to you out in there, Cyberland. And this will also be archived later. It's a good resource in case you miss any notes. You can come tune into the web later. It's pretty much all I have to say. We're only going to be here for an hour today, so Jim will try to make his brief, and we'll have time for some questions. We do have things coming up in the fall on Arctic, on cooperation within and among Arctic states and Arctic and non-Arctic states. We're going to have a program on One Issue, Two Voices, our series there on privacy at the border. And the DHS head of privacy is going to write for the Americans, and the Canada's Privacy Commission will write for the Canadians. So this will be the first time that we've had government people writing our articles. So that should be interesting too. So stay tuned to the website. And if you have any suggestions for things we ought to be looking at, I see folks from different areas around town, please let us know. We're always happy to explore new topics. So with that, let me turn it over to Jim, and he'll take over from here.
Thank you, David. I am, as David points out, a Canadianist, but in the last few years I have been particularly focusing on the relationship of Canada within North America and the idea of Canada as part of a regional association. And that, together with my strong interest that I've had for a long time in the issue of civil and human rights, I decided that it would be interesting to explore the concept of a Charter of Rights for North America, not because I think that that is a near-term possibility, but because doing so really helps you to tease out some of the other issues that occur and that arise from the subject of the regional economic development, the closer cooperative ties among these three countries, and many of the challenges that they face as they try to make their relationship more functional and more profitable for everybody. So this is really not as much in some ways about a Charter of Rights as it is about asking some important questions or raising some important issues about North America and about what it represents, what it could represent, and what Mexican, Canadian, and American relationships really are about here in the 21st century. So I start out, as you can see up there, with a thesis statement, and it's a very long thesis statement because dealing with a Charter of Rights is kind of a multi-layered process. First of all, you have to ask the question, why bother? Secondly, does it even matter? Thirdly, if it does matter, then on what basis do you get three different countries to agree to a Charter of Rights? And so in dealing with those kinds of questions, and fourthly, in a way, what do you really hope to achieve with it? So that leads to a very long thesis statement, which is part of a work in progress. This is very ongoing. It's still very rough. But as I mentioned up here, a hypothetical Charter of Rights for North America offers an institutional means for discussing the concept of North America as a distinct regional community and the principles, values, and goals that may lead to increased continental cooperation. The concept is feasible because of the theoretical aims of liberal idealist, especially liberal commercial approaches to international relations in the area of human rights, the general legacy of regional charters of rights, the increasing convergence of ideological and cultural values among the principal North American countries, and the desirability of deepening the North American relationship toward achieving mutual beneficial goals. Typical boilerplate. And it goes beyond simply playing with tinker toys, which I love to do, playing with rights. Hey, what would we throw into this mix and why, et cetera. So it's really kind of an expose in many respects, and it really, challenges us to think about, what is this continent about? What is this relationship about? Does it matter? Could it matter? Where could it go? In breaking down these themes, one of the things I wanted to discuss is, well, what is the rationale for even approaching this subject, for even discussing the possibility of a Charter of Rights? Why would it matter? Is it even feasible? What sort of theoretical considerations do we have to take into account? Now, at the outset, I have to tell you that I am not traditionally an international relations person. International relations theory is not my forte. International human rights, which is a subfield of international relations, is. So I'm still someone who very much, when it gets into the theoretical questions, has to sort of go back to square one and think about these things in that particular way. A good part of that for me, though, is I get to approach it from a fresh perspective. I'm not already wedded to a particular approach, but instead look at a situation and ask myself, what would make the most sense in explaining this as a reasonable, functionable kind of project. And one of the things that really occurred to me is this deeper question of what would Mexico, Canada, and the United States have in common? What would be the basis for even discussing a rights regime? And for me, the basis of that really has to do with the fact that NAFTA is a commercial relationship. It is about trade. It is about business. And therefore, there must be an underlying assumption that the countries involved share certain expectations and even principles about the way a marketplace should function. And those principles are tied to liberal concepts of rights and liberties, et cetera. So that provides sort of a starting point, particularly because all three of them want economic stability, and that gets into the issue of democratic institutions and the belief that democratic institutions provide a better basis for a successful economy, at least in the long term. But the other thing that occurred to me, as I point out there, is the fact that many people criticize international institutions, international organizations, as essentially window dressing for a process, as a realist will, that's supposed to be anarchic. That it is not only idealistic, but it's naive to think that creating institutions will change the behavior of states. One approach, which is one I've actually experienced in my more traditional area of comparative politics, that seems to offer some interesting responses to that kind of criticism, is the area of neo-institutionalism. Now, traditional institutionalism, also known as formal legalism, was largely panned in the last half of the 20th century as being a little too simplistic. It was the approach whereby people simply evaluated a country on the basis of their institutions. And, on a simplistic level, that can lead to people, for example, reading the Canadian Constitution and concluding that Queen Victoria actually runs the country, because that's what the actual institutional description says, without realizing how parliamentary government works. And the office of Prime Minister isn't even mentioned in any constitutional documents in Canada. So institutionalism, in the traditional sense, has some very strong limitations, or severe limitations. Neo-institutionalism, on the other hand, was developed in the latter part of the 20th century and has really picked up some momentum among many comparativists and even among some international relations scholars as a way of explaining how institutions do serve a useful purpose and how in particular they affect the behavior of political actors, including states. And part of that has to do with the idea of rational choice, what I call avoidance, and that's linked to the historical institutional approach, the idea that people basically get used to historical institutions. Institutions themselves seem to generate a kind of a response that people have. People develop expectations in relationship to institutions. And the rational choice aspect of that has to do with the fact that whether you think the institution is useful or not, its very presence forces you to react to it. It almost is kind of like chaos theory in the sense that if you have to change, even to the slightest degree, your response to something, it can have a chain of reaction effect that can change everything else. And one way I like to illustrate this point is to talk about having a chair in the middle of a room. And someone could say, well, putting the chair in the middle of the room is not going to impede me. And that's true. But you still have to decide, are you going to step around it? Are you going to knock it over? Are you going to jump on top of it? And what are you going to do? At some point, it's going to alter the way you approach things. And institutions such as charters of rights have often the same effect. People can say, well, look, this is cynical. People don't really feel bound. States don't really feel bound by these charters. They are not going to alter their behavior if it's contrary to their state interest. But they still have to, even if they're going to be dismissive, they still have to dismiss it. They still have to justify it somehow, or they feel at least compelled to do so. And that's where normative institutionalism and conceptualism come into that play. Because, again, it forces states and other political actors to rationalize, if that's what they're choosing to do, their behavior in response to values that are projected by the institutions and that people, at least at some level, consider to be legitimate. So it does have a constraining effect. The idea of what's the term up there, the logic of appropriateness. Even Stalin felt he had to defend what he was doing as appropriate behavior. Even he felt somehow constrained to present an image of himself as being a good guy, even though he had absolute control over his country. He still felt, to some extent, constrained. Even a Hitler felt somehow constrained to justify himself to the world. And so part of this argument is that creating a charter of rights, a regional charter of rights, also creates an expectation of appropriate behavior. And that can have an effect on the behavior of states, even if they find a way to get around it. So I start out by basically defending why a charter of rights even makes sense, why it matters. And then what I do is I place it, whoops, sorry, too far, into, I did want to go, okay. Then what I do is I place it into the context of the charters that have come before. And we start out with the international covenants, which the United Nations produced two particularly significant ones: the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social, and Cultural Rights, which has been signed by most countries in the world, which was generally accepted, although the negotiation leading to it obviously had, a great deal of disagreement that went along with it. And indeed, the fact that it was divided up into two separate documents really represented the politics of the Cold War, with the Eastern Bloc countries arguing that, it's really about economic exploitation, and that's what we should be focusing on. Western countries tending to focus on traditional civil and political rights, especially property rights. So you have these two very different documents dealing with two very different areas. But the fact that it purports to be a universal charter does mean that it runs into questions of cultural relevance, cultural differences in interpretation, ways in which different regions have to deal with different economic and political issues, regionally and within their own countries, etc. And so what you had also was the rise of regimes of regional charters of rights. The African Human and People's Rights Charter was a very interesting example of that, focusing not only on traditional liberal-based rights, but also on many of the traditional cultural rights associated or expectations associated with traditional African culture, and finding ways to try to bridge the gap, particularly in the post-colonial era. The Charter of the Arab States, in some ways attempts to do the same thing. The European Charter of Human Rights is often cited by people who work in this area because European values and Eurocentric perspectives are often so considered to be so much closer to North American values and perspectives. But interestingly enough, I found that the Charter of Rights of the Organization of American States was probably the best model to use in trying to define some of this language, in large part because Canada, Mexico, and the United States are all signatories of it, and obviously at some point all agreed on some of the wording and some of the expectations that are represented by it. And it also represented some of the same sort of political and economic changes and developments that are occurring now in North America, or have been occurring for a long time in North America. So it represents some similar expectations and goals on a political and economic level that a North American charter would address. But, as you might expect, with the North American Charter, I'm trying to develop something that's much more specifically tailored to the experience of those three countries and the differences between them and the rest of the Americas. Now, in order to have a feasible charter, you have to have an agreement on what rights mean, on what the basis of rights are, and that's not an easy thing to do. The very language of rights is very easily conflated. It's very easily something that is understood differently by different people. I've done research before on the concept of collective rights in Canada, and I often get into big arguments at conferences because I conclude that many of the things in Canada that are called collective rights are either not really rights or not really collective. You know, they're either individual rights with a group language attached to it, or they're actually collective interests where they attach the word rights. Of course, that says something very important about the concept of rights. It has such a strong appeal on a political level that people like to use that language. You know, I'm not simply someone who deserves that job. I have a right to that job, or I have a right to the last piece of pie, or I have a right to something else. The idea of entitlement, the idea that this is something of a higher nature, but it also undermines our understanding and expectation of what these rights are. And in particular, if you're taking countries as different as Canada, the United States, and Mexico, you have to find some kind of common ground. And that's particularly true in dealing with Mexico, where there has been a very different emphasis on the meaning of rights within its constitution and within its political history. So there's two ways to approach this. One of them is the Engelhardt, Bassanez, Nevitt approach. They are three empiricist, political, statistical type people who've done some interesting studies during the last several years on values in North America and have come to the conclusion that Canada, the United States, and Mexico, in terms of political values, are coming closer together, that even Mexico is beginning to adopt ideas and ideals and principles and lifestyle choices that are coming closer, at least especially in terms of northern Mexico, that are coming closer to their northern neighbors. So the idea that Mexico really belongs in the Latin American camp and is very different from the, you know, Anglo-Saxon heritage of English-speaking Canadians and Americans, they say that that's not really so true anymore, that Mexico is looking more northward than southward. And likewise, Canada and the United States have been sort of accommodating themselves to some of the expectations that the Mexicans have. Engelhardt's study focuses very much on the difference between materialist and post-materialist values. The materialist values are much more directly related to economic welfare, economic sufficiency, feelings of personal security. Post-materialism deals with more ephemeral values, values about what is the good life, what does human happiness really mean? You know, is this all there is? Does money buy happiness? Those sorts of things. And, of course, with the increased prosperity of North America, they argue, post-materialist values will become even stronger. As they demonstrate in their studies, they've already become in all three countries. Not quite so strong in Mexico, strongest in Canada, etc. But some of that is also attributable to the ideological values. And first of all, you're starting with three countries that are all liberal democracies. But liberal democratic ideology is a very malleable tradition. It really revolves around 5 core principles: a belief in an abstract notion of property, individualism, freedom, autonomy, and equality. Beyond that, you can have all sorts of variations, all sorts of different emphases, different ways of understanding what a liberal democratic society should be about. And so on the one hand, you do have overlap among these three countries, but you do have some significant differences that have to be bridged, and that's part of the challenge of coming up with a Charter of Rights that's going to be acceptable to all three countries. Canada has sort of a dueling tradition between the classic liberalism that we find embraced in many of its constitutional institutions in terms of its own approach to rights and liberties, and a communitarian tradition that's particularly popular among many Canadian political theorists, political philosophers, people like Charles Taylor, etc. I have done studies that to me, indicate that the communitarian tradition is very real in Canada, but its presence has often been exaggerated, in large part because communitarianism, for many Canadians, just provides the wonderful symbol that we are different from the United States. It's part of a tradition I call negative nationalism. You know, we are Canadians because we're not Americans. So define what an American is, and we're not that. So Americans, as we find down there on the bottom, are often categorized in terms of a very strong adherence to classic liberal or libertarian values. It's very much part of the American mythology, the rugged individualist who goes out into the frontier and, you know, carves out his own destiny, etc. But many political theorists over the last 20, 30 years have begun to emphasize a strong civic republican tradition, a tradition of civic virtue and civic duty that they claim is very much part of the American revolutionary tradition, and they claim was more important than the liberalism of John Locke in defining the American Republic. As in many cases, I think it's both are present, and indeed the interplay of both really is responsible for many of the different political opinions, political camps that you find in America today, as with the different classic liberal and communitarian traditions in Canada. Mexico, on the other hand, has a liberal democratic tradition that arose out of a classic conservatism that was associated with the Spanish colonial regime, one that uses the institutions of the church to help frame its concept of a hierarchical, sturdy, less malleable kind of society, one in which paternalistic understandings of the role of government are much more readily acceptable, one in which people are more accepting of their place within a particular society and their role within a society. No, that was, as I said before, something that was particularly emphasized during the Spanish colonial period and very much associated with the years of dominance by the PRI in Mexico. But it's one that has changed considerably over the last 200 years, and in particular during the latter half of the 20th century. And the typical paternalism, the typical patriarchal type of liberal democracy that characterized Mexico during the early and middle part of the 20th century increasingly gave way to a more traditional social democracy that we associate with the welfare state, the New Deal, or the rise of Fabian socialism in Britain, and other developments that you found in Europe. And that plays a much more prominent and self-conscious role in the development of Mexican liberal democracy. So my argument at this juncture is that all three countries are liberal democracies. All three, therefore, share certain core values, particularly in terms of accepting certain basic principles about the marketplace, especially relating to property rights, which many scholars have asserted is really the basis of all civil rights as opposed to human rights. But that we have to take into account that there are different ideological traditions, and you need to be aware of them if you're going to carve out rights that are going to be acceptable to the people of all three countries, even if they are sort of coming closer together in some of their basic values. And obviously, we wouldn't be talking about this at all if it weren't for NAFTA. NAFTA really not just created a free trade area for North America, but it also created a dialogue about the idea of North America as a continent and what the countries of North America really have in common and whether they do share certain goals. Obviously, it reflects free market interests, and with free market interests come traditional civil and economic rights. But it also reflected certain concerns, especially over the issue of sovereignty, with many people being very concerned about the role of NAFTA in terms of undermining sovereign control of policymaking, decision-making, etc. And so that's something you have to take into account if you're going to construct an institution of this nature, that you're going to have to address the fact that people are going to want to continue to feel that their country still vests sovereign control, even if they accept a treaty and incorporate it as part of their law. Another thing about NAFTA is that it deals with three federal countries. And I've done a separate paper that appeared in the Journal of North American Studies, Norte America, that addresses this subject, because you have three countries, three federal systems, three different traditions of federalism. You have Canada, which is a country which is more relatively decentralized in its federalism, but has very strong institutional mechanisms for addressing the shared sovereignty that comes with federalism. You have the United States, which also has very strong institutional federal mechanisms, but is much more highly centralized than Canada's federal system is, largely because of the control over natural resources that exists at the provincial level in Canada as opposed to the United States. And then you have Mexico, which is more highly centralized traditionally, but is weaker in terms of its mechanisms, which has undermined federalism in the past, although in recent years there have been attempts by the Mexican states to assert a more proactive role in federal negotiations, in exercising concurrent powers, and even in dealing in matters of trade. The theme of subsidiarity is something that has been particularly studied in terms of Europe, and particularly in relating to Europe's one great federal power, which is Germany. It also applies somewhat to Belgium, and trying to think anybody else. But in particular in Germany. Germany developed a tradition whereby the German national government would be the primary negotiator in its relationships with the rest of Europe, but left to the different Länder the responsibility for actually applying many of these standards, which means that in Germany, different German Länder, or different German states, often have different ways of interpreting the way that European conventions, European requirements, policies, including rights, are often applied in practice. And this is a principle that often works very well, because if you don't do that, you're more likely to have resistance. You're more likely to have people who do not want this one-size-fits-all approach to an interpretation of policy or even rights. And so in constructing this kind of a charter, you need to take those kinds of considerations into effect, particularly in terms of the idea that in different provinces, different American states, different Mexican states, you may have different ways of wanting to apply these kinds of standards. And finally, the whole idea of a culture of rights, and I sort of began with that idea, the idea that rights are actually popular. Now, we might not think so if we look, for example, at American politics right now. We find a lot of criticism of courts as being somehow activist. And yet, many of the people who claim activism are still very wedded to their idea of rights. Oftentimes, their anger is that there are rights that belong to those people, not to me. My rights are important. Those people's rights, not so much. So, even if you are, say, an American conservative, you might say, well, I'm not really on board with these criminal rights, but my gun rights or victims' rights, oh yeah, I mean, those are important. And it really gets back to the fact that the language of rights reflects the importance of rights, at least in popular imagination, in many liberal democracies. And international relations theory, especially liberal theory, often pays a great deal of attention to the way in which states will respond to popular perceptions of their role in the world. Obviously, we're here in the Wilson Center. That was very much a part of Wilsonian international relations, and I think it continues to be so. And that's another reason why I think that this idea of a Charter of Rights is not necessarily an unfeasible idea, even though there may be a good deal of resistance to it in the current climate of skepticism about international organizations, concerns, very vocal concerns by some parties about sovereignty and issues of that matter. I still think that there is a great deal of support for the idea of expanding rights in substantive ways and not just in normative ways. So I've been writing up, as you have here before you, a draft of what such a charter might look like. And it's divided into three main sections. There's actually a typo in there. Section 3 is actually mistakenly on your copy listed as Section 4. I don't know why. I thought I learned to count when I was in grade school, but apparently these things happen. And Section 1, dealing with general obligations, is really an opportunity to deal with some of these bigger political issues and concerns and perhaps sources of opposition. The idea that there is a general culture of rights that should be promoted and does find some acceptance within all of the countries of this continent. The question of mutually binding enforcement, the idea of leaving it to each country to be responsible for the actual implementation, to try to reinforce the idea that a regional charter of rights does not necessarily threaten the sovereignty of any particular country, that especially one that voluntarily accedes to it. Part two, civil and political rights, are really those rights that particularly emphasize the abstract notion of property. They come from the classic liberal tradition, and they are associated with the marketplace. And if you're going to have a charter that arises out of a relationship that has been initially framed by an agreement such as NAFTA, one of the easiest places to start with are the tradition of rights and liberties that arise out of the marketplace. Property is particularly important because, as I explain to my students, property is not just the stuff you own. Property, in the abstract sense, is really everything that extends from us, everything that we can exchange in a marketplace, including ideas, including emotions. You know, and I tell my students this, and they say, "What do you mean by that?" I said, "Well, if you cause emotional distress to someone, you can sue them and get money for it. You're exchanging your lack of emotional well-being for money. There's an exchange that's going on. We tend to abstractly think of everything attached to us as property. And so there's the old adage of all rights are property rights, the idea of speech as a property right. Speech is property, not just in terms of a marketplace of ideas, but the fact that some people actually sell their speech. And this, of course, ties into intellectual property, which is a very important topic under NAFTA, etc. So that extends to other individual rights in various ways. It's a way of thinking about rights where the marketplace helps to define it in ways that can be acceptable to all three countries. The judicial enforcement is really a matter of institutions, and it gets back to that issue of federalism, subsidiarity, the different mechanisms that have been used in the past, and whether or not we want to forego the tribunal approach of NAFTA for simply, again, returning to an assumption that the judicial systems of each country will be responsible for applying these rights as it does any treaty obligation. Now, there can be some problems in that respect. We found in recent years the United States Supreme Court has been willing to use creative interpretations of treaties to sort of say, this doesn't really count, or, or simply or for states to blatantly ignore treaty obligations, and the federal government saying, what can we do? Texas already executed them. What can we do, et cetera. So there are problems in that area, and that's something that a charter of this nature would have to address if it was going to take this topic seriously. And then, thirdly, economic, social, and cultural rights. This is a section that would be particularly interesting to Mexico and Canada because they have done more experimenting in this area than the United States, which has been much more traditional liberal in its approach to rights and liberties. Many of these things are things that are addressed not judicially but legislatively also. And certainly labor rights is something that already has been negotiated under NAFTA. This would simply reinforce those ideas, particularly in a way that might, induce Mexico to be much more aggressive in the way that it applies those standards, especially in the pursuit of better economic relationships with its neighbors, etc. The environmental issues, again, phrasing them as rights really helps to address some of the great concerns that occur in this area. Language, there is great concern about culture. This is an area that is particularly important to Canada. The idea of being able to protect its linguistic issues, particularly Quebec, which is interestingly has traditionally been less worried about the effect of NAFTA, the effect of continental cooperation on its ability to protect its culture, etc. But it's an issue that arises. It's an issue that arises in the United States. The ability to sort of calm the fears of people that this is going to strip them of their cultural identity, etc., I think is important to add so that you can diffuse possible sources of objection in that particular area and respect those ideals. And finally, indigenous peoples, very touchy area. Canada and Mexico are two countries that refused to ratify the UN Charter of Indigenous Rights, and it really relates to some very touchy problems in this area, problems that Mexico has recently been trying to address, but problems that all three countries have had to address in the past, particularly in terms of southern Mexico and the fact that NAFTA has not been as effective in southern Mexico as it has been in northern Mexico, economically speaking. So that's what the book is really going to try to do. And the rest of it is kind of, an interesting way to talk about the different policy implications, the different ways of dealing with it, et cetera. So that is essentially how I'm addressing this particular issue. And hopefully you've had a chance to read through this and maybe get some ideas. So at this point, I'd like to entertain your questions.
Comments?
Yes. Yeah.
Stephanie, can you hold it? We're recording this, so you might as well wait for the microphone. Thanks.
Okay, so my name is Stephanie Van Lanke. I'm a scholar at the Canada Institute as well. I have a question about, I guess, the practical implications of this. Besides you, who are the charter entrepreneurs out there? Who are going to be the actors driving the process of this charter for North America? That was my first question. I also had a second question regarding very interesting thing that you mentioned at the beginning of your presentation regarding expectations of appropriate behavior, a very good concept in international relations. And I was wondering where these expectations come from. Do they come from common values? Do they come from mutual arrangements like institutions? And I think getting at this process is really key to the next step, which would be a charter. So those are my two questions. But great presentation. Thank you.
Thank you. Well, the first question, the same people who embraced NAFTA, the same people who were promoting it, are many of the same people who would like this to go further. Many of the, the various political elites. There are some organizations, academic organizations such as the Center for North American Studies at American University, et cetera. But they are small. They are not particularly powerful. What you have instead is really a coalition of various interests who find this to be a feasible topic. So it really depends on the political will at the very top. Now, supposedly, the political leaders of all three countries are devoted to the idea of making NAFTA work. They have dedicated themselves to that ideal, and so would be willing to sort of perpetuate greater cooperation. But in terms of a specific cadre of people promoting this, well, I'm kind of on my own on this right now. I mean, other people, I'm trying to think, there's a former congressman in particular who's been traveling the country who's really sort of promoting this idea. I can't remember his name right now. I want to say Boylston. That's not his name, though. But anyway, there have been some people who've been really, advocating this idea. But remember, in part what I'm doing is really an academic exercise. This is a way to really ask some questions about what does North America mean, if anything. Do these three countries really have something in common? And so in many ways, and I sort of stress that word hypothetical, there is no real movement to do this. This is just an idea which allows us to explore this concept of whether or not there is a regional identity in North America and what direction they may want to take. Now, your second question, I forgot. What was your second question again? Yeah, I think, again, with the evolution of any liberal democratic regime, particularly as they develop more sophisticated economic mechanisms and as they trade with other liberal democracies, they begin to adjust themselves to the expectations of that marketplace. I think you've kind of found that in Mexico in particular. For decades, Mexico really rested on the idea that the government is primarily responsible for directing the economic success and welfare of the country. And only really since the 1980s has Mexico's political culture begun to drift away from that expectation and to embrace the marketplace. And as it's done so, we find in many of these studies that people in Mexico, particularly, again, northern Mexico, which is one of the great problems, but particularly in northern Mexico, have begun to adopt liberal democratic values that would appear to Canadians and Americans to be more, for lack of a better term, conventional as far as they're concerned. I think this is something that inevitably happens when you have closer economic ties and closer relationships, particularly in a free market environment, which requires people to trust each other in the marketplace and to allow the marketplace itself to determine economic output rather than government regulations. This is certainly what's sort of happened in Europe to a certain extent. It doesn't mean that there isn't going to be a regulatory state, nor that the state does not continue to play the role that social democracy envisions for it, but that in terms of a belief in liberal individualism a belief in the concept of us as property bearers, the concept of equality that comes with an understanding of the way the marketplace works. Those values tend to be more firmly embraced, and then they can be institutionally supported in that way. So that's how I kind of approach that as well. And then when you have those institutions, there's sort of a reminder to people. It's like a string around their finger. Oh, that's right. We're supposed to believe in this stuff. That's right. So what are you going to do about it? And if you're going to do something bad about it, at least you have to justify it. Now, if I may just give one good Canadian example of that, the inclusion of Section 33 of the Charter of Rights and Freedoms. In the Canadian Charter of Rights and Freedoms, there is this clause called the Notwithstanding Clause. And it allows the federal and provincial governments to opt out of certain rights for a 5-year period. And it was really designed to meet the objections of some provinces which did not want to be tied to an absolute adherence to certain rights if it was not in their short-term interest. They wanted to be able to skirt certain rights, particularly in terms of, people in Quebec have actually used this to protect certain language rights which were deemed to have violated freedom of expression, French language protections, etc. We found this also in Alberta in terms of protections against certain policies which which were very popular but which nonetheless were seen as violating a particular aspect of the Charter. Now, many people who supported the Canadian Charter of Rights and Freedoms said, well, this just completely undermines the Charter. Basically, it means provinces and the federal government can, anytime they feel like it, just say, hey, we're going to pass this egregious piece of legislation, and it violates rights, but we're going to invoke Section 33, so, tough, what are you going to do about it? The truth is, it's only been invoked twice. And in both cases, it caused a political uproar. And it really constrained those governments in pursuing that course further. If you have to invoke Section 33, you must be doing something really bad. Now, that's not necessarily the case, but you see how this kind of creates that sense of appropriateness. And it can occur at the international level as well. Again, states which do not necessarily need to justify their actions. Hey, why are we oppressing these people? Because we can. What are you going to do about it? Instead, feel this need to justify what they're doing, either by covering it up or by rationalizing it in some way. And that does put a certain constraint on them. It can, to some extent, make it easier to get them to stop doing whatever it is they're doing in the long run. So the idea that institutions, by their very presence, can alter behavior, I think is a very attractive one, particularly for an idealist approach, or trying to justify sort of the promotion of idealism in international relations. So I like it, so I'm going to keep pursuing it.
Hi, my name is Keith. I'm from the Department of Homeland Security.
Mm-hmm.
And I was wondering where do you see maybe the greatest, where's the biggest leap that would be needed between the three countries in terms of their current laws or constitutions or traditions? What area would require the biggest reach to really come to an agreement?
I think indigenous rights, because there are some practical consequences for protecting it, because all three countries have different traditions of dealing with indigenous peoples, because indigenous peoples do not necessarily have a great deal of political support in any of those countries. So you have, for example, in terms of Canada, Canada has had, because of its colonial heritage, a very different way of dealing with indigenous peoples and their autonomy than, say, the United States. In fact, I was surprised that many Native Canadians said they actually would like the American reservation system. It'd be great to have a plot of land which is recognized by treaty as as having some kind of sovereign identity, which you don't have really in among the First Nations in Canada at this moment. So that would be a very contentious issue, and the very fact that Mexico and Canada did not ratify the UN Charter in this area sort of shows that there are some, serious problems, especially with Canada, which was a real surprise. Because Canada certainly, talking about constraint, and Canada likes to be perceived as the good guy and a country that takes care of its minorities and is sensitive to multiculturalism, and yet didn't go forward and endorse this universal declaration in this particular area. But so that can be a very touchy area. The environmental concerns can be actually one area where I've spent a good deal of time writing lately is property rights relating to natural resources. That's a touchy area. Now, NAFTA did exclude natural resources, particularly in terms of water rights, but that hasn't stopped people from being very concerned. And I know there's a case before the arbitration board right now about Sunbelt Water Corporation wanting to export water from BC, British Columbia being told that it can't do so, essentially suing the Canadian government now over this issue, and many Canadians saying, you can't have our water. That's, we need it. Maybe right now, not right now, but we may need it. We know there's these images of the country just being drained of all its water to feed, in their opinion, Las Vegas golf courses and things of that nature. So that can be a very touchy area as well. And that's surprising because, here I've been discussing how these abstract concept of liberal property rights are probably the areas where you have the most convergence, the most acceptance, and yet there are some specific issues about carving out exceptions. And Mexico traditionally has a constitutional protection over its natural resources. In Mexico, you can be a property owner and you can own the land, but products that come under the land, that belongs to the government. The government will not allow you to own that individually. The government wants to be able to control that resource for ostensibly the benefit of everybody. And so those are areas that could be tough as well.
Well, Jim, I want to ask about the whole role of multilateral charters of rights and how they work with national rights and sort of the Charter of Rights and Freedoms and our Bill of Rights, and how do you get like a multilateral charter, something like this proposes on a cranky country like the United States?
Well, the United States has ratified it ratified the OAS charter, it's ratified the UN charters, and it's often done so simply by claiming that our Bill of Rights really kind of covers all these things, or we cover it by legislation. We do take care of the social welfare rights that are enshrined in these documents by our social welfare policies. We don't abandon the poor. We don't abandon, now some people, of course, may disagree and say, well, maybe you do, at least nominally, but you don't do a very good job of it, or you don't do as good a job as we do. But that's one of the things about international charters, that they are subject to local interpretations and local applications. So you're going to have disagreements about how effectively a particular set of rights are, in fact, endorsed. And it's not just the United States.
For example.
For example, no, and I know, and although the United States is, again, the United States is interesting. When I've done work on comparative constitutional scholarship, the United States is interesting because its rights tradition really is very different from the rest of the world, because the Bill of Rights was introduced in the late 18th century, and it reflected late 18th century liberal values and the preoccupation with those liberal values, whereupon in many other countries their own constitutional rights were enshrined in the late 20th century following World War II and reflecting a very different experience and a very different regime. But interestingly, the United States has always been able to find, in the end, ways of agreeing with those rights regimes, and again, largely through legislation. That's one of the other things, too. I think in a country like the United States, people automatically tend to think that any rights agreement is going to involve the courts, and that's not necessarily the case. It can involve legislation. Most human rights in this country are legislatively guaranteed, not constitutionally guaranteed. And that's a tough issue for some people to get their heads around, because some people feel if it's not constitutionally guaranteed, then you can indiscriminately violate it anytime the legislature feels like it. But as countries such as Great Britain demonstrate, once you've made a commitment to some sort of major policy that promotes something that's considered to be a fundamental guarantee, if not an actual right, it's really hard to reverse that. For example, in the current political debate about health care reform, one of the basic acceptances is once comprehensive health care reform is passed, it would be extraordinarily difficult simply to repeal it, to undo it. You may adjust it, you may play around with it, et cetera, but if there was a real comprehensive national health insurance program, it would probably stay. It's kind of equivalent to the way in which Britain works with conventions. When you made a major commitment to something, going back is putting the genie back in the bottle is extremely difficult. And the same thing is true with any kind of commitment to human rights, even if it's only as a matter of policy or a matter of legislation. So I think that can work in that way too.
Hi, Christian Anger with the Canadian Embassy. My comments are my own and not those of the embassy or the government. You've mentioned NAFTA and property as the basis for a lot of your intellectual démarche. I'm wondering to what extent you see migration within North America primarily as, something else that may underpin, the interest behind the kind of work you're doing.
Oh, quelle bonne question. Parce que that question underscores the problem of sovereignty and the issues about sovereignty and the desire to thicken borders and protect borders, etc. But at the same time, if you have a strong rights regime and if you have a strong economic cooperative zone, etc., migration is less likely. People migrate usually in the vast majority of cases for economic reasons and not for other reasons. And if the economic need to migrate is gone, and that includes an acceptance of protecting certain economic rights as well as social and political rights, then people aren't going to feel that need to migrate. So the pressure is often taken away from that emphasis. So that is something, that has to be taken into consideration. The Charter, as I conceive it, does not deal with migration per se. It does deal with free movement, but not necessarily with migration. So that implicitly, therefore, remains the prerogative of the state. But hopefully it becomes less of an actual issue. And in the meantime, there is this protection of people who are not citizens of your country while in your country. This is something that's in the OAS Charter as well. On the other hand, on a personal note, people who know me know that, especially when I was here last time at American University, I am not a fan of the Western Hemisphere Travel Initiative. And I would like to see continuing cooperation in North America sort of reduce this theme of thickening the border, of creating this impenetrable wall that's supposed to protect us from terrorists, etc., and perhaps shifting more to the idea of a perimeter North American defense, but certainly one that does sort of break down these barriers and allows freer exchange between countries, as it does right now within the countries between their federal subunits. That would certainly be a personal hope of mine that may indirectly be affected by the promotion of this kind of a document, which kind of helps to create a sense of common expectations and values within all three countries that hopefully will also go hand in hand with greater prosperity, greater contentment at home, and less of a need to migrate.
Well, we're about running out of time, and I like to keep programs on time, particularly at the end of the day when we promise things will end at 5. It'll be nice to leave at 5. With Jim's assent, we will post these documents, the outline and his longer treatise on the website in PDF. So when those should be up soon, and the video will be up soon as well. Thanks, Jim, for sharing your thoughts and your sort of work in progress with us. It's nice when you get someone who's only here for a couple of weeks to see what they're thinking about and not have to wait almost a year and a half or 2 years sometimes for the book to come out. So when the book does come out, you let us know, and we'll have you back. But please let me thank Jim for coming.
Thank you.
Wish him well.
Thank you very much.